The following 5 tips will help you do much better at your deposition in any civil case. Tip number 1: answer questions, don't tell stories. Your job at your deposition is to answer the questions that you are being asked by the deposing attorney. Your job is not to tell stories and not to try to convince that lawyer that you're right and their client is wrong. Your job is not to try to win the case because you're not in court, you're not in front of the jury or a judge. You should answer the question asked and then wait for the next question. The more you talk unnecessarily, the more likely you are to say something that might not be consistent with your other statements, or it might not even be true. Not because you intended to lie, but because you didn't remember something correctly, or simply your story doesn't quite add up the way that it could have if you didn't speak more than you had to. Example: you're being asked, have you been convicted of a felony in the last 5 years? Your answer should be yes or no. Not no, but I was convicted 10 years ago. No one asked you about what happened 10 years ago. If you're being asked, then you're going to truthfully answer. Another example: do you own or rent your residence? The answer is I own or I rent. Not I rent, but I own these 2 other properties in this other state. This is not none of their business. They don't need to know that for all kinds of reasons, for privacy reasons and for many other reasons. Answer the question asked and don't answer any other questions that have not been asked of you. Tip number 2: do not exaggerate and do not make your case sound better than it is. Almost no case is perfect. Well, some cases might be considered perfect, but generally most cases have strengths and weaknesses. You don't need to make your case sound better than it is because it will only hurt your credibility. And if you're caught exaggerating one time, this will cast doubt on your other testimony. Examples: you're a plaintiff in an injury case. You've been in an accident, and the attorney who is taking your deposition is asking you, did you injure your head in that accident? And you say yes. How about your neck? Yes. Back? Yes. Left knee? Yes. Right knee? Yes. Ankles? Yes. It just doesn't sound like it makes sense. It's very hard to injure every single part of your body in a car accident. It's perfectly fine to say truthfully that my left shoulder was injured, but not my right. My left knee was hurt, but not my right. Also, if you suffered relatively moderate injuries and you are saying that 2 years since the injury, you feel exactly the same pain as you did 2 years ago, this also doesn't make much sense. It's perfectly fine to say that you're pain free now, if it's true, or that you're much better. Examples from the world of employment law and wrongful termination. Do you believe that you've been discriminated because of your age? Yes. How about race? Yes. How about religion? Yes. Disability? Yes. National origin? Yes. I mean, come on. Did the employer really discriminate against you based on every single classification that I mentioned? This is highly unlikely. Testify about what truly happened. Testify about the strong facts in your case. And don't just add things up because you're trying to throw kitchen and sink during your testimony on the other side. It's not going to help you. It's only going to dilute your story and make it sound like you're just trying to go with anything you can to see what will stick. Not a good idea. Doesn't impress judges, doesn't impress juries, doesn't impress lawyers. Tip number 3: never lose your cool during your deposition. Just because the lawyer who is asking your questions is becoming angry or dramatic or he's putting a show for his client doesn't mean that you should be matching that energy of drama, doesn't mean that you should get angry as well. On the contrary, you want to send the opposite message. No matter how angry the lawyer is going to get or how dramatic, it doesn't faze you. You're not intimidated by it. You're going to continue being polite, professional, and diplomatic. You're going to send a strong message with your presence that nothing can disturb your peace. You have nothing to hide. You have nothing to lie about. You're going to tell your story in a calm manner without any temper, no matter what that lawyer is doing. Very important. Number 4, do not promise to produce any documents if you're not sure that you have them or you're not sure that you should be producing them. If the lawyer who is taking your deposition is asking you for certain evidence or for certain documents that you might not have yet produced in discovery, you could say, I could check. I'm not sure if I have those documents. I don't know where I'm going to check. You shouldn't be saying, yes, I'm going to go to this place or that place, to this file folder or to this folder on my computer, and I'm going to get those documents. No, you should talk to your attorney during a break about the existence of those documents and whether or not you should be producing them before you produce documents that you shouldn't be, and before you generate this additional work of looking for documents, looking through documents, and then producing them. And my tip number 5, do not be afraid to admit mistakes. And this applies more to employment cases than to other cases. If the lawyer who is taking your deposition pulls out one email from you that sounds very angry, and that lawyer asks you, hey, Mr. Plaintiff, do you think this is the appropriate way to talk to your manager? It's perfectly fine to say, it's not. I recognize that I reacted. I was emotional. I was upset about what was going on. I was afraid of being retaliated, of being terminated, whatever. This was not the ideal language. I could have phrased this better. It's perfectly fine to say it in response to anything that objectively looks like it shouldn't have happened on your part. It doesn't kill your case. In most cases, it won't kill your case. It only makes you sound more credible and more truthful, more realistic, and more honest. And your credibility, as you may already know, is everything when it comes to your testimony. Keep these 5 tips in mind when you're about to testify at your deposition, and they will be very helpful to you making the most out of your testimony for your case.